Welcome to Jackson Lewis's podcast, We Get Work. Our podcast identifies issues that influence and impact the workplace and its continuing evolution, and helps answer the question on every organization's mind: how will my business be impacted? As remote work remains the norm for many companies, employers face obstacles in creating compliant multinational workplace policies addressing basic workplace law issues like discrimination, leaves and accommodations, and harassment. On this episode of We Get Work, we discuss the federal and state laws impacting U.S. companies with global remote work arrangements and how employers can implement policies that adhere to these regulations. Today's hosts are Chris Anderson and Bryn Goodman, principals, respectively, in Jackson Lewis's Greenville and New York City offices. Chris and Bryn, the question on everyone's mind today is, what can employers do to minimize compliance risks for U.S. employers with global work arrangements, and how will that impact my business?
Thanks, Alicia. As Alicia said, I'm Chris Anderson, and I'm a principal in the International Employment Practice Group at Jackson Lewis. And we are doing a series on global remote work of U.S. personnel, U.S. employees going outside of the U.S. for a short-term period of time. And Brennan and I will talk about some of that, some of those parameters around that today. But this is the third installment in this series. We've done immigration, and then we've done tax and benefits. And then today we're looking at the employment considerations, both on the U.S. side and on the international side, when someone who's a U.S. employee goes and works outside of the U.S. for a period of time. And I've got Bryn Goodman with me today. Welcome, Bryn.
Hi, thank you so much for having me.
Yeah, you bet. And Bryn, can you give a 1,000-foot view on your practice really quickly?
Sure. I'm a principal in the New York City office at Jackson Lewis, and I like to act as sort of outside general counsel, general employment counsel to my clients. I handle a wide range of things, but one area that I handle quite frequently is helping either employers who have operations abroad and are bringing people to the U.S. sort of navigate the differences between their operations abroad and how employment works in the U.S. And then also, handling the surprise employees who move abroad and how to navigate that situation. But my practice also includes, litigation and general advice and counseling.
Right on. Thanks so much for that overview. And in your practice, Bryn, how does this come up when international remote work of a U.S. employee for a short-term period? And let me qualify it too, that when it's their personal decision, right? This isn't about the employer sending them or assigning them to a country or relocating to a country. This is someone that even if maybe you do know about it, maybe you don't know about it, but they go to another country for a short-term period of time. How has that come up in your practice, just in a few practical ways?
I think a lot of times employers come and want to, establish a remote work policy, have procedures in place because they know that their employees often travel or they have some flexible work schedule. And so it can come up where someone has gone through that, that policy they've put in place, taken the right procedures, notified the employer. But a lot of times I get a call when we find out that someone has been living in Portugal for 4 months and we didn't know they were there, and what implications does that have for us? And I think, you mentioned earlier you had 2 other podcast series in this series where you talked about immigration and tax implications, which are some of the biggest issues that you have to deal with. So certainly go back and listen to those episodes for those of you who haven't yet already. But then, my specialty is not immigration or tax. I deal with sort of the other employment issues, which can be wage and hour, discrimination, harassment. Leave issues are often a huge thing under the ADA and under FMLA. So that's when it usually comes up for me, is when I get a call with someone panicked.
Yeah, that's great. And I'm glad you mentioned the other 2 installments, because it was on purpose the way that I thought through the framework of this kind of 360 view of global remote work. I wanted to look at, and there's other areas we could talk about, restrictive covenants and IP and lots of things, data privacy, but looking at the 3 big areas, big buckets: immigration, tax and benefits, and then employment. It's not that one's more important than the other, but I think it sounds like you likely would agree, Bren, that the immigration is the first gating mechanism. You got to know their status to work in that country. And then tax and benefits often becomes very material based on the time they're in the country and some other factors as well. But employment, equally material. And so as we dive into that, what are some ways that you've seen in your practice that, let's focus on U.S. law for a minute, that you've seen U.S. law potentially continue to apply or absolutely continue to apply, or anything satelliting around U.S. law when someone goes and is working outside the U.S.?
Well, when it's sort of a surprise that the person moved abroad, I think one of the considerations that I mentioned briefly is whether or not there's some implication for an accommodation, either because they traveled abroad for their own serious medical condition or to help a family member with some kind of medical issue. So, while you obviously want to deal with the implications that you discussed earlier, you also need to be mindful and careful, what is actually underlying here, and do I have some obligations under the Americans with Disabilities Act or under the Family Medical Leave Act to either offer leave or to offer remote work as an accommodation. And also, if I do that, what kind of precedent am I setting for my other employees? I want to comply, but I also want to make sure that I'm not setting bad precedent, or putting the company in a situation where we're doing something that's going to get us into hot water with respect to taxes, et cetera.
Yeah. And with that, let's go a little deeper with that, even with ADA and with the Family Medical Leave Act. Is there any affirmative obligation you've seen in any case law or anything kind of bubbling up that would lead an employer to have any kind of requirement to allow someone to remote work outside of the U.S. if they have family there, for example?
Yeah. So under the disability law, you have to examine whether it's a reasonable accommodation. And I think if you didn't have a remote work policy in place, or you didn't otherwise allow remote work, you'd have a better argument to say, we don't allow this. We're not set up for this. This is unreasonable for us to allow remote work. A leave of absence, that's something that would be a little harder to deny if you could give a leave of absence for that position. But the remote work piece, it really turns on whether, is this something that you do all the time? You certainly would need to think twice before denying it if it was based on a disability. You really, you obviously can't deny the trip to go for the doctor's appointment if you provide anyone else medical leave normally. But the remote work issue, you do need to look at, what have we done for others?
Right. And so we have to really do need to look at precedent setting. And you and I talked briefly before of the podcast about that sometimes there could be precedent setting issues with, I think you mentioned even unions, and the potential for, once you start allowing something, it gets harder to say no. Because from my standpoint, dealing with this, I know that there's employment risk based on the territoriality principle. When you start working in another country, that I want to say to clients, you can say no, but I hear what you're saying. You have to be consistent about it, and you need to pre-think it. And if you said yes to certain people, then talk about that for a minute. If there's anything about the union context or in the collective bargaining that you've seen that could, the employer should be aware of.
Right. And so, to be clear, many of these laws would not apply extraterritorially in general, but if you have a U.S. employee that the law applies to, and they happen to go abroad and not tell you, or go abroad and it wasn't at your direction, you didn't sanction it, but they've been working abroad, or they asked to work abroad, which is the other scenario. Sometimes the U.S. law will apply. So when they ask, it could apply if it's tied to a reasonable accommodation or tied to a request to care for a family member. And again, the leave issue is an easier one to deal with, but the remote work one, it becomes more complicated in the environment we have now, because people have been so accustomed to working remotely, especially after post-COVID. And so people think there should be no problem going abroad. Why would I ever be denied the opportunity to go care for my aging parent in another country and also still make money? But yeah, it would depend on the policies. And oftentimes there's remote work rights under the collective bargaining agreement, there's a negotiated provision or clause of that contract that gives the employees certain rights that, again, the NLRA would not apply extraterritorially. But if the CBA allows you to work remotely, does it have any kind of provision that says we only allow you to work remotely in the US, or did we not, was that not considered? And do you, what implications is that going to have on people in the future? I did want to mention one other thing. There was a recent Second Circuit case dealing with a pharmaceutical company where an employee applied for FMLA. And again, the rights under FMLA are to take leave and intermittent leave, but not necessarily work remotely. And the court actually said your rights under the FMLA are not to work remotely.
Yeah, so like what you said, that you can take leave, but it doesn't mean that you can work. You can take, if there's a leave, you can't say you can't go to another country, but you can definitely say you can't work there.
Right. And that eliminates your problem too, Chris, when you're advising about, what exposures the company have now under foreign laws, under international, under various, right? So I think employers, while you want to say it's fine, you can work remotely because we're all digital and it doesn't make a difference. And here you are, sitting in another state on a podcast with me. So why couldn't people just be flexible? The laws are not set up to allow that. And if you allow someone to work from another country, they, from your perspective, I mean, to put it back on you, if you don't know what the employment laws are in that country, I mean, that could create exposure for the U.S. company permitting someone to work there, correct?
Right, for sure. And definitely the longer it goes on, the more material that risk is going to get as a general rule. And it really is going to be country dependent, of course. But we know that most countries around the world apply the territoriality principle, which simply means that if you're on their soil doing work, we can't say it's without risk that person can bring an employment claim at some point. If everything goes wrong in the relationship, for example, there's a global rift and they get swept up into that and they're still in that location, could they bring a claim for severance or some other unfair treatment in that country and possibly have a lot bigger benefits than they would get in the U.S. from an employment standpoint? And most countries outside the U.S. definitely typically have greater benefits from an employment standpoint of leave, Christmas bonuses, which is like an extra month pay a year, more vacation, severance, notice, all those things built in most cases. So absolutely, that's true. While I balance that with not wanting my clients to have a hair on fire moment whenever someone's gone for a few weeks or a few months, if they're allowing it, if they've decided they have a policy, which Ren, you mentioned the need to have a policy, and I can't stress that enough as well, the need for a robust remote work policy, a remote work agreement that sets expectations, you're still a U.S. at will employee, U.S. law applies, all of those things, and we help clients with that all the time. But once that person is there and they're working, if it's allowed for a period of time, analyzing that on a case-by-case basis is important. Often the employment risk for a short-term period, meaning a few weeks to a few months, is not going to be as material as tax and potentially as immigration, of course, but still something that has to be looked at for sure. And Bren, back to the U.S. issue on wage and hour, FLSA. We talked about that when we connected before. I'd love to discuss that for a few minutes. It's a question, honestly, an open question for me. If someone's a non-exempt employee in the U.S. and then they go overseas for a vacation or with their spouse, whatever the case may be, that's precipitating them asking for personal reasons to go, and they are going to work for 2 weeks, 2 months, 3 months, whatever that period is, short term, with the full intent to return, would the FLSA apply equally to them during that period as it would if they were sitting in the U.S.?
Well, yeah, I mean, they're not. The FLSA, again, doesn't apply extraterritorially in general. If you're an employee in Germany, you're a German employee, it's not going to apply. But if you're a U.S. employee that's traveling, yeah, it would apply. And it does create an issue for non-exempt employees. There's already enough difficulty trying to track hours, even when you're on the same time zone or you have set work hours. Now try and establish that with different, scheduling meetings over different time zones, whether you're, do you have your email remotely? Are you working all the time? It's very difficult to be able to track your hours and whether or not you should be paid overtime. And, that's something that is difficult in general, especially for smaller employers or for employers that have a lot of employees who are paid on a salary basis, but maybe their duties are not really properly exempt, because there's really a misconception that just because you get paid a salary, you can work anytime and you're not entitled to overtime. But that's not the case. As you and I know, you have to actually have, meet a certain salary threshold as well as a duties test. And a lot of people aren't exempt from overtime. So if they're traveling, you need to also, be able to set proper work hours, track time, pay overtime as you normally would in whatever jurisdiction they would be working in, whatever type of employee they are and where they're located in the US. You want to be mindful of those laws, not the laws of where they happen to be temporarily.
Bren, there's something else I wanted to bring up really quickly, and that's a big phenomenon that I'm seeing in more and more countries over the last few years of what's called a digital nomad visa or a remote work visa, basically where the law is catching up with the reality that countries are saying, we need a category for this. We need to be able to put a name on what these individuals are doing who are coming from the US or other countries to their country, and they're working, but they're not working on the local economy. They're not doing anything on that local market. There's no local employer. They're just doing foreign work. They're just, in our case, we're talking about basically doing services for their U.S. employer on U.S. payroll, the whole thing while they're there. And it's something, many, many countries have them. I looked a few weeks ago, and it's in one reference I had 70 plus countries have them now. It's probably bigger than that. It's, we're seeing them all the time, all over the world. But the big question I have, and I'd love to hear kind of your thoughts on it, is do you think if someone has a digital nomad visa, often they have a 1-year period and then a renewal period for another year that you could be working from that country for your U.S. employer. How does that affect, if at all, kind of our conversation about U.S. law applying if someone's there? Do you think there'll be a market effect? I mean, I think we haven't seen test cases on this yet. Likely we will. But what would be your opinion on that if someone's there for a year and then another year and they have authorization to be there working for the U.S. employer in terms of U.S. law applying? If
they're not residing in the U.S., they're not maintaining a U.S. residence. They're not maintaining sort of a U.S. work presence. They're not visiting the U.S. because sometimes there are cases where you have someone coming back frequently, once a month, once every other week, in which case I think the U.S. laws would continue to apply. But I think if your residence is abroad for some semi-permanent time period, I think there's an argument to be made. And again, you're right. I haven't seen cases on this yet, but there's an argument to be made that the U.S. law would not apply. I think that it might be difficult for you to sort of benefit from the U.S. and federal and state discrimination laws, wage and hour laws, et cetera, because you're no longer really working under those conditions. I think, though, that there will be developing case law in that area. And I think that to the extent that the company is located in a certain place in the U.S., certainly we will see employees trying to take the position that they're protected by the U.S. state and federal laws.
Right. Yeah, agreed. And it's something on the other side, on the foreign side, this is an open question. So I think I would want everybody listening, clients, anyone who happens to listen to this, who deals with these issues, if you're in HR and you're dealing with it, just always ask the question, whether you ask it to us or to some other advisor, but just ask the question because it is a material thing. And what I'm finding is that it's open in many countries and what I mean by that is it's an immigration driven thing. It's a digital nomad visa. So it gives you authorization to be there. And I think we often will connect immigration, tax, benefits, employment, all kind of as a lump. Oh, if I can be there, authorized without having to have a work permit, then clearly I'm not local employment law doesn't apply. I don't have to pay taxes, but that's not always clearly defined, or sometimes not defined at all in these digital nomad visa statutes or other regulations that promulgate them. So it's something to definitely look at. And on top of that, practically speaking, I've talked to colleagues within our global alliance, L&E Global, that Jackson Lewis is a member of, and all our fantastic colleagues around the world through that, and then other colleagues outside of that. And I've had many of them say our position is that employment law does apply, even if someone is remotely working for a period of time under a digital nomad visa, that they could bring a claim for entitlements, and which in my mind seems to be going against the attestation the person would be giving and getting that visa, because they're saying, hey, I'm not a local employee. I'm a foreign employee, and I'm not. And part of the visa requirements are often to attest and give your U.S. or other foreign contract or offer letter and give your pay stubs and show that you're not a local employee. So again, we haven't seen test cases, and I think in the absence of those, there is a vacuum there, and people are going to take different sides of it. So it's just, again, wise for our listeners to be asking that question, not only on employment, but tax as well. Definitely listen to that podcast too. But we know for immigration, it's a good tool to have. And last thing I'll say on that, it's important for listeners to know that even if someone gets a digital nomad visa in one of these countries, and they don't always give a year, but usually the major ones I've seen give about a year, and then even a renewal period, you don't have to give that amount of time. You can say, get the digital nomad visa, but we'll allow you still to go under what's in our policy. And that might be 2 months or 3 months, whatever it is. And they can still have that coverage that it at least gives them some protection from an immigration standpoint for sure. And then maybe from these other ones as well.
I think that's an important point about the colleagues that you spoke to in the Global Alliance saying, we're going to take the position that the employment laws here apply, the international laws wherever the person's located. Because I think obviously, even if we sitting in the US, if we received a claim from someone who had been working abroad for whatever it might be, failure to accommodate, failure to pay proper overtime, something under US law, and you take the position that, they're not in the US, so the US law does not apply to them, logically speaking, someone's going to find that some protections apply. So whether it's the US protections or the protections of the foreign country, it's better that you're prepared and aware of what could be your obligation. And if you get in front of it and you set the policies that limit the time frame, like you said, or you're aware of sort of what would work under the various jurisdictions about limiting the time frame and protect you. Or you make sure that you're providing consistent responses to requests for accommodation to remote work abroad, then you'll be in a position where you as an employer have made it clear what the expectations were. And so while the law is developing,
right,
at least your company policy can be consistent, and you have that argument for yourself.
That's a great point. That's a really great point. And one final thought on that is what you said a minute ago that was also so great, is just that we have a situation where if we don't know, or if we can take the position that U.S. law may not apply anymore on these, hypothetically digital nomad visas, you're there for a year and maybe renewing for another year, whatever the case may be, then that's maybe the argument we'll start seeing. Not who knows, but I got to be covered somewhere. I've got to have some coverage. If I'm not covered in the U.S., why can't I avail myself to this coverage? And I haven't seen that test case, and I've done probably remote work analyses in 100 plus countries at this point. But I think it's a developing area of the law, which makes it fascinating to watch. And that's a great point.
Right,
So,
but knowledge is power. Knowledge is power. So
right.
Making sure that you have some system in place to have the employees communicate to you where they are, to update their address, to make the request more formally for you to consider it, is a better situation to be in than sort of operating without knowing what's going on.
Yeah, absolutely. And that's kind of part of what I want to end with risk mitigation strategies, and that was a great segue into it, because that's the best one, is to be consistent and to have your policy in place, to be consistent with it, to get advice on it so that you're thinking about all the attendant issues as you put it together. Remote work agreement when someone's gone, to set expectations of U.S. law applying and that they're still a U.S. employee and all of that. But also let's end with this. Have you dealt with the risk mitigation strategy or dealt with clients that say, well, they want to go and we don't have employees abroad, so we'll just make them a contractor? Have you dealt with that?
Absolutely. I deal with that all the time. And it's a misclassification issue, and you're going to have a problem on a number of levels for a variety of different reasons. But if someone's doing a job in the US and they're an employee, under most bodies of law in the US, whether it's, are you an employee for the purposes of the Fair Labor Standards Act, like you mentioned before, or are you an employee for purpose of unemployment insurance, whatever it might be, if your job duties and your relationship to the company is serving the company in the same way when you were classified as an employee as it is when you move abroad and you're classified as a contractor, you're probably misclassified. And then, there are a host of different issues, and it really requires sort of like a balancing of your business interests and the risk. And it depends heavily on the country that you're talking about. US, we're used to at-will employment, but most foreign countries don't have at-will employment. They don't allow employers to terminate people with or without cause or with or without notice, and have employees have the same right where you can sever the relationship with sort of no further obligation. There is often, leave to pay out. So you accrued a certain type of annual leave or paid time off, or there's severance obligations, or there are other obligations, other entitlements, or sometimes you can't even terminate someone unless you have a basis for cause, right? And that's something that, just because you classify the person as a contractor and allow them to move abroad, if they're truly an employee, you might get yourself into hot water over there. Right. So you really do need to take a closer look at these issues before allowing someone, just thinking that classifying as a contractor is going to solve all your problems.
Absolutely. And to end, I would just add to that, my clients and where I do counsel on a weekly basis is clients will say, what do we do if we need this person, or they have a sick parent and they can't come home? And many of my clients have like a 6-month or a 3-month, it ranges based on risk appetite and a lot of different things. But wherever they land on their policy of allowing this, if they do allow it, there's cases that come up. A lot happened in COVID, but even now there's cases where the person needs to stay longer than that. It goes past 6 months, it goes into a year. What does that look like for the person? So along with changing the contractor status, which I've had a lot of clients want to do, and, again, if you weigh the risk, and to your point, Bren, are willing to change the job duties, or if that's possible to recast it, there's ways you can do that, but it's not going to be without risk. But something that a lot of clients do think about. But then I would want to end with the other two that I see all the time, and that's using an employer of record to employ the person on your behalf in that country. And that's usually, I have clients, this person's indispensable, we have to have them. What's the kind of a middle ground? We don't want to set up an operation, which will be the other mitigation strategy, which many clients don't want to do for one person or even a few if they don't have business there, right? But they may get an employer of record, an EOR, to employ that person. And then finally, some countries allow, mostly in Europe and a smattering of other countries, will allow you to register as a non-resident employer, where you're raising your hands to employ a person, but you're not raising your hands for permanent establishment or corporate income tax presence purposes. But that's a whole other analysis there. But something to think about, when you get in that tight spot, or when it's a close case in terms of all the things we talked about, especially if you have a foreign attorney, or we're telling you with our colleagues through L&E Global and other colleagues saying we think that local law does apply or could apply, you need to be willing to pivot and think through if you want to make it more long-term. So we'll end with that. Bren, thank you so much for being part of this today. I really appreciate it.
Thank you so much. This was a lot of fun.
Thank you for listening to Jackson Lewis's podcast, We Get Work. Focused solely on workplace issues, it is our job to help employers develop proactive strategies, strong policies, and business-oriented solutions to cultivate a workforce that is engaged and stable. Please tune into our next program, where we will continue to tell you not only what's legal, but what is effective. We Get Work is available to stream and subscribe on your streaming platform of choice, including Apple Podcasts and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com.